Nobody in the Supreme Court chamber expected what was about to unfold. Judge Neil Gorsuch pointed directly at Steve Harvey, his voice sharp with authority. "Mr. Harvey, as a comedian, I find it difficult to believe you can grasp the seriousness of this court's proceedings. But what happened next would leave the entire judicial panel and everyone in the room absolutely shocked. Make sure to watch this entire video and subscribe to our channel because we bring you the shocking confrontations that mainstream media will never show you." I bet nobody knew what Steve Harvey was doing in the Supreme Court that day. The case of Johnson versus Educational Broadcasting Corporation had reached America's most prestigious court, representing a critical lawsuit that would determine educational content standards in television broadcasting. The case would specifically decide on federal funding for educational programs targeting minority communities. Steve Harvey, 67, was one of America's most recognizable television hosts. Known for bringing Family Feud into millions of homes, Harvey was also a radio host, comedian, and motivational speaker. But the real reason he was in court that day involved a past that nobody knew about. Judge Neil Gorsuch, 57, was a Trump appointee known for his conservative views on the Supreme Court. A Harvard Law School graduate, Gorsuch was particularly known for his sharp questioning and strict adherence to protocol. He had served 10 years on the federal court in Colorado before his appointment to the Supreme Court in 2017. The courtroom was unusually crowded that morning. Media representatives, legal academics, and curious citizens had gathered to follow this extraordinary case. Nobody could quite understand why Steve Harvey was participating in this case as amicus curiae, friend of the court. The case was about content standards for educational programs produced by Educational Broadcasting Corporation with federal funds. How programs targeting minority communities would be evaluated was a critical issue. Harvey's involvement had been interpreted by the media as celebrity activism. Judge Gorsuch's questioning began with a sharp opening. "Mr. Harvey, while your experience in the television industry is appreciated, do you believe you have sufficient background in the complex constitutional matters before this court?" Whispers rose in the chamber. Journalists readied their pens. This question was designed to corner Harvey. Harvey approached the microphone and responded in a calm voice. "Judge Gorsuch, before answering your question, I'd like to quote from the decision written in Hazelwood versus Kuhlmeyer." Gorsuch's eyebrows furrowed. This wasn't the type of response he had expected. "In that case," Harvey continued, "the court stated that educational institutions' authority over freedom of expression must be consistent with societal values and educational mission. I've been trying to achieve exactly this balance on television for 25 years. Gorsuch's expression changed. This wasn't just a simple celebrity. "Mr. Harvey, are you reciting legal precedents from memory?" Harvey smiled. "Judge Gorsuch, perhaps it's time I told you. I earned a master's degree in communication law and policy from Kent State University in 1995. My thesis was specifically on the Red Line Broadcasting versus FCC case and educational broadcasting." There was an incredible silence in the courtroom. Journalists looked at each other. This information had never been heard before. "Furthermore," Harvey continued, "I've been an active member of the Federal Communications Bar Association for the past 15 years. I've published 8 different academic articles on educational content standards in television broadcasting." Justice Sotomayor leaned forward. "Mr. Harvey, why isn't this information in the public record?" "Justice Sotomayor, I never felt it necessary to highlight my academic background in the media world. But the issue we're discussing today is about children's right to education. This isn't a show for me, it's a mission." Gorsuch tried to regain control. "Well then, Mr. Harvey, according to the Turner Broadcasting versus FCC decision, how do you explain that educational content requirements might violate the First Amendment?" Harvey opened the file he had brought. "Judge Gorsuch, the Turner decision is certainly an important precedent, but that decision was about private channels' programming choices. What we're discussing is educational content produced with federal funds." Then he turned the page. "A more appropriate precedent is the Rust versus Sullivan case. In that case, the court stated that requiring federally funded programs to meet certain content standards was constitutional." Justice Thomas, famous for rarely speaking, asked, "How do you view the constitutional basis of this distinction?" Harvey's answer shocked everyone. Justice Thomas, it's based on the spending power doctrine established in South Dakota v. Dole. The federal government can use tax revenues to encourage certain behaviors within constitutional limits. Justice Alito joined in. But Mr. Harvey, couldn't these educational content requirements lead to viewpoint discrimination? Excellent question, Justice Alito. However, as seen in Rosenberger v. University of Virginia, educational content curation differs from viewpoint discrimination. Especially for educational content targeting children, Ginsburg v. New York also provides us with a clear framework. The atmosphere in the courtroom had completely changed. Harvey wasn't just memorizing precedents. He perfectly understood how to relate them to each other. Judge Gorsuch was now speaking in an entirely different tone. Mr. Harvey, what's your view on the government speech doctrine? How does the Pleasant Grove v. Summum decision apply to this case? Harvey's response caused admiring "wow" sounds to rise from the gallery. Judge Gorsuch, Pleasant Grove is important, but more relevant to our situation is Walker v. Sons of Confederate Veterans. In that case, the government speech doctrine for specialty license plates can't be directly applied to educational broadcasting because educational content has a public forum element. Specifically, he continued, as also seen in the Betsy Ross Heritage Foundation versus Pennsylvania Department of Education decision, educational content can carry both government speech and public forum elements. This hybrid nature requires a more nuanced constitutional analysis. Justice Barrett asked in amazement, Mr. Harvey, the Betsy Ross Heritage decision is quite obscure. How do you know it in such detail? Harvey answered proudly, Justice Barrett, I'm not just a television host. I've been working in communication law for 28 years. Every new decision directly affects my work. Chief Justice Roberts finally spoke. Mr. Harvey, if the court accepts the framework you're proposing, what would be the practical implications? Harvey seemed prepared for this moment. Chief Justice Roberts, there would be three fundamental outcomes. First, federally funded educational programs would remain within constitutional guidelines. Second, educational content for minority communities would be protected. Third, private broadcasters' rights would also be preserved. Moreover, he added, this framework is also compatible with the Central Hudson test. The four-pronged test used for commercial speech regulation can be adapted for educational content regulation. Judge Gorsuch was now speaking in a completely respectful tone. Mr. Harvey, the legal analysis you've presented today is extremely impressive. Your constitutional law background is truly remarkable. Harvey responded with a modest smile. Judge Gorsuch, law is my passion. Television is just the platform. My real purpose is to strengthen society through education. The court unusually granted Harvey permission to extend his time. This was a very rarely seen courtesy. Finally, Harvey said, this case isn't just about broadcasting. Since Brown versus Board of Education, we've been fighting for equality in education. Television is the most powerful educational tool of modern times. Using this tool correctly is a constitutional imperative. Justice Kagan asked, visibly impressed. Mr. Harvey, have you ever considered a legal career? Harvey laughed. Justice Kagan, I'm already in a legal career. I just practice in a television studio instead of a courtroom. When the court session ended, spontaneous applause rose from the gallery. Justice Gorsuch approached Harvey and shook his hand. Mr. Harvey, the legal perspective you gave us today is truly valuable. Your constitutional scholarship is impressive. Harvey replied, Judge Gorsuch, I'm not angry that you initially underestimated me. It showed me how quickly we can make judgments. Harvey's side won the case 7-2. The Supreme Court decided that federal funding standards in educational broadcasting were constitutional. However, the real victory was Harvey proving his 28 years of legal expertise. The media announced the story with the headline, From TV Host to Supreme Court Scholar. Law schools began inviting Harvey as a guest lecturer. Harvey, with his usual humility, said, I just did my homework. Judge Gorsuch, in an interview after the decision was announced, said, Mr. Harvey taught me an important lesson. Expertise doesn't just come from titles. It comes from passion and preparation. Steve Harvey, when he asked a contestant on Family Feud the question, what precedent is most cited in the Supreme Court, made everyone laugh. When one of the answers was Brown versus Bored, Harvey smiled and said, "Survey says," and got a perfect hit. This extraordinary confrontation taught America an important lesson. Real legal brilliance can emerge from the most unexpected places, and instead of making assumptions, we need to listen to people's real capabilities. If you enjoyed this remarkable story, don't forget to hit the like button and subscribe to our channel. Turn on notifications for more inspiring stories about the power of preparation and unexpected excellence.